Okay, so this is the bad in the clubhouse, and Anna did these Bitmojis for us, and we were vastly entertained because they're supposed to represent people that work with us or around us. So this is Cody. Cody is a student teacher at the district, and he seems good. He's also science endorsed, which makes all the difference in the world, right? So you hired him because he was decent as a student teacher, and he's science endorsed. He was pretty good in his first year. A few typical new teacher troubles, but you know, he's getting slowly better. Problem is, this summer he married into the family that owns like half the county and has a lot of political clout in the community. And his wife also works in town at the bank, probably in the loan department where farmers get loans, and she knows everybody. They're building a new house, so they are putting down deep roots. And he's also gotten elected to the local church board, so he understood me when I quoted Ephesians, unlike you bad administrators out there. Problem is, Cody, now that he feels like he is secure, his attitude has completely changed. He loves to stir the pot. He's chitter-chattering in the teacher's lounge like a middle school girl. There's a fellow teacher that allegedly had an affair that he heard about from his in-laws. And now he makes little snippy comments about it all the time. He speculates all the time about it. Every little rift between the teachers, he's jumping in. And he's also fighting with the existing staff about what curriculum should be purchased as you're making this decision. At a recent science department meeting with the admin team, he said, you know what, if you don't agree with me, I'll just have Dave donate the money. And then we'll let him pick. And obviously he thinks his father-in-law is gonna pick the curriculum that Cody wants. Every Friday and Saturday night, he is just consistently stirring the pot. And now teachers, his peers, are getting concerned and frustrated, and they're starting to come complain to you. Quick footnote, I love this. Notice that they don't tell Cody to knock it off. They come to you and tell you to tell Cody to knock it off, which I think the whole social and emotional learning piece that we should put in the curriculum for students, we also should hold teachers accountable to, because they should start with Cody, but you know how that is. But bottom line is, it's pretty clear that Cody thinks now that he's married into the biggest money family in town, he's got the power to basically do what he wants. His in-laws are real supportive of the school because they were good parents when their kids were students, but now their only basis of information about what's happening at the school is Cody, and so they're not above calling in a favor. And now that Cody's their inside man, so to speak, it's gotten worse. So what do you do about Cody? I think the first thing we need to start talking about here is lesson plans. And I need to swap this slide so that people that are watching it there can see it. So it says, the kids are much better behaved since I crossed out lesson plans and wrote evil plot on my planner, which makes me laugh hysterically. Okay, so if we're gonna give a reprimand, Bobby mentioned this before, it's not just a matter of you write something up, you stick it in this file and you call it good. There is an actual statutory process. Reprimand is covered as something that you're empowered to do by the statute, but the unicameral, you know, what they giveth, they also taketh away. They give you the power to give a reprimand, but they also make you jump through certain hoops. So before you issue a reprimand, you have to confer with the teacher. Cody, you're doing this stuff, this is not so bueno. What do you have to say for yourself? You have to give the teacher a chance to speak up. Now, I've had administrators say, I don't want to do that because all Cody's gonna do is make excuses and tell me a bunch of lies. Look, I don't care what Cody says in response. You can believe him or not believe him, but giving him the chance to say the words that come out of his mouth, that is what is statutorily significant.
And why would you not add that to the reprimand?
Right.
When we met, you told me you weren't even at the bar on Saturday night, but I saw a Facebook post from you in the bar on Saturday night. Yeah. Meeting with them can oftentimes, if they have just a crap attitude about it, put that in the reprimand, right?
You were defensive and evasive when we met. Yeah.
Yeah, what we're trying to do here.
Absolutely. And I love putting stuff in there if they're surety with you when you actually meet.
When we met to confer about this, signals your statutory compliance as well.
So this next bullet point, tell the teacher the reason for the proposed action. Sometimes administrators get hung up on that. No, Mrs. Johnson said she didn't want to get involved. So when she told me that Cody was talking crap in the teacher's lounge, and now I can't say that because he'll know that it's Mrs. Jones. Look, at some point in time, just fundamental fairness requires you to tell the teacher basically what's gotten you all fired up. So if Mrs. Jones is such a baby that she doesn't want her name involved, I would actually, step one, I think, is counseling Mrs. Jones about what's expected of a professional. But number two, if you really want to protect Mrs. Jones because her husband farms for this family or whatever, you don't have to tell Cody who. You can say, staff members have reported to me, blah, blah, blah. Or you can even say, I have been informed. I don't like that passive voice because it just makes you sound weak. But you do have to tell the teacher, whatever the reason that got you fired up is, you have to tell the teacher what it is. I saw you interact with the student in an inappropriate manner. I saw your Facebook post. I have had complaints, whatever it is. And then you give the teacher a version to present his or her version of the facts. Principals, this is exactly like Goss versus Lopez due process for kids before you impose a disciplinary consequence. You just do that same process with teacher. So they told me you were talking crap. What do you have to say for yourself? Let Cody talk. I don't care what he says. Make some good notes because whatever he says, we might be able to use against him. But let him give you his version of the facts. After that meeting, sometimes at that meeting, we'll have a draft reprimand ready to go, and you can give it to the teacher right then and there. I kind of like embroidering in anything that the teacher says. So if you want to add that in, you can just give the teacher the reprimand separately a little bit after the meeting. If Cody does not agree with what you've given him in the reprimand, he may grieve it under your negotiated agreement. If there is no grievance procedure in the negotiated agreement, the statute gives the teacher the ability to challenge this through the chain of command. Quick footnote, there is a UNICEF rep out there who's new-ish, although they're all new right now, who takes the position that the teacher can do both, and that if you don't tell them both, that you've somehow committed a violation of the statute. I don't agree with that. And so we continue to say either grieve it or contest it through the chain of command, but just be prepared that there's kind of a snotty UNICEF rep out there that will tell you you've done it wrong. Don't panic, just say, hey, we've talked to KSB and we don't care what you say.
So one quick thing to add, Karen mentioned, and it happens a lot. This may be on the slide. So if you bring the reprimand with you, then you've sort of signaled that you never intended to take whatever they said seriously. And that can be okay if they smacked a kid, right? Okay, just wanted to confirm, thought so, here you go. But I've had in at least a couple of cases recently, a UNICEF rep, or whatever they call them now, an area rep, has been at the meeting with the teacher and did not let the school know, which I don't like. They always used to call and at least give you a heads up, and have said, well, how do you have the reprimand ready if you still had to meet with the teacher and ask what happened? So especially,
the answer to that is, well, I thought I knew what had happened, and this meeting has not changed my mind. So this draft can now be formal.
Exactly. So there's an answer for it, but just know that they're thinking about that, those couple statutory steps, the flurry of activity before you can actually give them the document. So if it makes you feel better to have it, to organize your thoughts, you should totally put it together beforehand. But there's nothing wrong with having the meeting and saying, I'm going to think about it, and then sending it 5 minutes later either, if you're worried about it.
So when you call us and tell us, we talk it over and we decide that we're going to do a reprimand, we send you a memo that kind of explains this process, so you've got kind of step by step. And we also send you a draft reprimand. That doesn't mean you have to give it to them right then and there. You can wait and fiddle with it. One other thing is we're talking, and you're going to see this as a theme that develops. The NSCA is losing membership. Like, millennials don't want to pay to be a member of the union unless they get something. And I think that is why we're starting to see UNICEF reps or area directors or whatever the hell they're called, like, try to show that they're valuable. So I think you should expect more kind of picky little things like this because they're showing their value. And so just don't be thrown off your stride by that. I think you should kind of expect that. Okay, so this was the last bullet point, was the point. There's no mandatory format, but you should say in that grievance that they do have the right to appeal. And then we always say you are directed, if you disagree with anything I've said, you are directed to file that disagreement with me in writing within 7 days. That's not in the statute. The reason we say that is because if the teacher doesn't say anything, then 7 days later, we take the position that you've admitted everything that we wrote in this document. If they do file a response, absolutely, positively, never write this down. Never let the teacher have the last word. And so we, again, I think as part of the effort to show that they're valuable, we're seeing more UNICEF directors help their teacher write a response. And then we need to respond, we call it a reply to that response. But so that kind of goes back and forth. But so this all is stuff that we put into the grievance that isn't necessarily required or in a format, but that we include. Last thing, a few evaluation models now are including all kinds of forms. Like Talented, I think, has a form for a reprimand. Use whatever form you've put on file. If you've put a form on file, you've kind of limited yourself. But we can always, don't let the form drive it. We can always get around it. Anything else on that? If you are struggling with exactly how to articulate what's in a reprimand, I love this. You know, I taught business and professional and interpersonal communications back in the day, and I love this FRISC model, which is a way to have a fierce conversation. So first, you say what the facts are, what did they do, and why is that a problem? Secondly, what's the rule? What rule did they break, and how should they have known about the rule? Secondly, why does it matter? This is the part that sometimes we miss. It's obvious to everybody that you shouldn't hit a kid, but saying striking a child is corporal punishment, that's a violation of the law. It also is damaging to your relationship with students and the community. That impact step makes your document way more powerful. And if you can connect it to kids, that always makes us stronger. The S is what specifically do you want them to do? You must never again put your hands on kid in anger. Cody, you must immediately decease from having conversations which have a negative cultural impact on the school district. Be real specific, because if the teacher is wanting to play games with you, they're going to say, I didn't know what I was supposed to do. And so specifying exactly what directive you want to give them is important, and then including the consequences if you don't.
Yeah, real quick, I just got the question last week. I can't put an improvement directive in a reprimand though, right? And the answer is absolutely you can, right? Again, there is no form, there's no requirement. What's required by the statutes in Rule 10 is in those, but it doesn't say that you can only use a reprimand to call out the bad behavior. Then you must have a separate improvement or remediation document to fix it. Just not true, right? The only way that that would change is if your board's policy requires you to do separate documents for separate steps.
So I've done reprimands, and this one I might. I've done reprimands where I direct them to read a book. Cody, you are required to read John Gordon's Energy Bus. Do it, because that you're being reprimanded for being an energy vampire. There's nothing that says you cannot do that. And then put in there what's going to happen if they don't. Now, quick footnote, we're kind of vague when we say what's going to happen. We say things like you will be subject to additional employment-related discipline up to and including the possible cancellation or termination of your employment, so that we don't want to lock ourselves in. If this happens again, I'm going to cancel you. We want to like have it be lots of bad things will happen, including this really bad thing, but it could be other stuff too. And then finally, knowledge, showing that the employee knows you're documenting. There's no statutory requirement that the employee agree. That signature line on the reprimand form that we give you is not that the employee is saying, yes, boss, thank you so much for giving this to me. It simply acknowledges that they have gotten a copy and they know it's going to be in the file. So I love this FRISC model. I like these kind of little mnemonics. For the record, it also works really well with kids and spouses as a model for having a difficult conversation.
Co-workers.
Anything else?
One quick thing, we put in our form reprimands and we send them to you. You must let me know if you have any questions, right? We make it very specific. So this knowledge component is, yes, they know that they got it, but we direct them. Don't come back 2 months later and say, I wasn't real clear on whether I had to read the Energy Bus or something else, right? We put any part of this that you disagree with, you have to respond, like Karen said. You have to let me know if you have any questions as soon as you have them.
Yeah, and we put a timeline on that so they don't play games. Absolutely. So this goes back to when you meet with Cody and he tells you, oh no, I don't even go to the bar. If you don't believe the teacher, that's fine. And one of the problems is when people violate social norms by just lying to you, that is like such a social norm violation. Sometimes people don't know what to do. So here's your marching orders. If you don't believe them, you can say, I'm sorry, I find your explanation not to be credible. I believe you are minimizing your misconduct, or I believe you've been dishonest with me. I wouldn't use the L word. I don't say you lied or you are a liar. I do say you attempted to be dishonest or you dissimulated, and kind of use some other words to kind of dance around it, but say so. If you don't believe them, you should say so. And then say why. I do not believe you because I find the student reports to be credible. I do not believe you because I saw your Facebook post that you were at the bar. I do not believe you because of your long history of engaging in similar conduct, whatever it is. And again, this is someplace where we can be really helpful because we've thought of a lot of ways to say you're a liar, liar, pants on fire. So if you're struggling with how to write it, reach out to your attorneys because they probably have written it somehow. And then the last thing is when you don't believe them and it's like a he said, she said kind of situation, this is my go-to, which is the even if. Even if it's true that you weren't at the bar, I still believe that overall you've been talking crap about the district. Even if you only grabbed the kid by the shoulders to stop him from falling down while you were screaming at him, you should be reminded that you never touch a kid. So those are the kind of ways to dance around that who's telling the truth question if you don't have a Perry Mason moment when the teacher just admits that they did everything that you said they did wrong. And then when you're unsure of the facts entirely, you don't know who to believe, I still do a written documentation that we are reprimanding the teacher if this happened, and if it didn't happen, we are reminding you that that all teachers are expected to not touch kids in anger, not get drunk at the bar and flash the bartender. We're trying to think of examples that haven't happened. So that's what you do. If you're not sure, you say, I'm reminding you that this is a professional expectation so that you've got an anchor dropped. If this behavior continues, you have a way to get at it. Anything else on that? Finally, this is so this, again, this goes back to the idea that Cody's signature at the bottom of that does not mean it's collaborative. This is not an IEP meeting where the parents get to speak in, the employee doesn't get a chance to. We just recently had an employee and UNICEF rep that sat down and wanted to tell the principal, we don't like how you've written this, rephrase this. And so the principal sat down and let them edit his reprimand and then redid it and gave it to the teacher. This is your document. He does not get to tell you what your thoughts are. He does not get to tell you what your employment expectations are. This is your document. You present it the way you want to. So here are the common mistakes we see. First off is shortcuts in the investigation or relying on hearsay. Look, I heard this. I know it's true. I'm just going to jump straight to the chase. I don't want to play patty cake anymore. You have to try to get to the original source. You have to try to find out exactly what happened. Doing things like checking your video cameras, checking social media, that's sometimes seems like they're just slowing you down. You can find great stuff there that you maybe didn't even know existed. The flip side of relying on hearsay is ignoring hearsay. I'm involved in a situation, a student situation right now, where everybody and their brother wants to say what's hearsay. Look, just unless you've gone to law school, you probably don't understand the hearsay rules, and that's not me being mean, that's just me telling you the truth. So if 6 different kids tell you that this happened, even if, or that Cody said this stuff, even if that's hearsay, that doesn't mean that you as an administrator are not entitled to say, overall, I believe this happened, right? If Cody walked up to a kid and said, I'm so mad at you, I hate this school, and one of these days I'm gonna get you, even though that is him, Bobby's reporting to me what Cody said, that can be an exception to the hearsay rules if Cody is giving you his mental impressions and all this stuff. So I guess my point is figure out the best you can what was said, but don't be all so hung up on hearsay versus not hearsay that you watch Law and Order all the time and you think you know, that you don't rely on information that is important for you to know about in your building.
One quick thing to add, we hear it all the time. Well, you can't believe any of that, it's all hearsay. Number one, yes, we can. We're not in court. This is a meeting with me telling you to stop being a jackass. Number two, hearsay is admissible in personnel cases. Yes. Now, the board is supposed to give it less weight than more direct types of evidence, but unlike a court where they could say that's hearsay, none of it's coming in, these are, to the extent they're formal due process hearings, they're still just administrative proceedings. If that will come in at the board hearing, why would you exclude it from your reprimand document?
Everybody that's watching on the pinned video, this is Cody who just walked in, who we've been talking about. So you see what a crappy employee he is. He walked out of the webinar to take a phone call. So we'll be putting that reprimand in your file. So anyway, yeah, if you're worried about hearsay or evidentiary issues, honestly call your lawyer and have it be somebody that does a lot of teacher personnel cases, because hearsay is, we can do all kinds of good stuff with hearsay. Don't let that slow you down. The other thing that administrators sometimes do is they don't bother to get statements from the teachers or the kids or whoever in writing, especially parent complaints. If you can have a parent reduce that to writing, that makes life way better. So get everything written down that you can. Don't skip conferring with the teacher. even if Cody is a pain, even if you know he's going to lie to your face, you still have to sit down and give him a chance to tell you what he said. And then this one, I don't care if you show up with a draft reprimand, but if Cody tells you a whole bunch of new information and you just slide the reprimand across the desk anyway, that does kind of look like you've predetermined things. And again, the UniServe reps are starting to call us on it. So that's one option for Cody, is to give him a reprimand saying, knock it off, stop talking crap about the district. A second option is to go ahead and put together a formal remediation or improvement plan. So I'm going to swap screens. And I love this cartoon. If you wait long enough, difficult people either quit, retire, or die. That's my management style. And that is an uncomfortably common management style of some school administrators. So you don't have to wait for them to die. You can do something sooner. So I am an old school, you know, when I was in teacher college, it was all Madeline Hunter. It wasn't all the new stuff that's Madeline Hunter with a new label. So I just love this quotation from Madeline Hunter. It's easier to help a poor teacher grow than to dismiss that teacher. Now, when I first got into the teacher termination business, I actually disagreed with that. I thought I started writing improvement plans to have better documents to fire them. But I don't think that's true. Oh, I'll look at this.
I've done this presentation with Karen where she's talked about this quote, and I know how she really feels about it. So.
It's true that if like you walk into a classroom, I think you pretty much know if the teacher's got it or they don't. I'll just be flat out about that. I am surprised, I will confess, I am surprised at the percentage of teachers that do get better when we put them on plans, even though I'd rather fire them. So here are some facts about remediation. They are not statutorily required, just like Bobby said, or whoever it was that said that.
You have to remediate them. You don't need a remediation plan.
You don't need a formal improvement plan. But a surprising number of policies require improvement plans. And I'm just going to drop a footnote here. If your evaluation policy says anytime a principal marks a teacher as anything less than exemplary, he or she is required to write an improvement plan. To me, what your board is really doing is telling principals, give everybody an A+. Because there are times when you might want to mark somebody down and not do a full-blown plan. So I try to get rid of that whenever I can see that. But in some cases, there may not be a requirement to remediate. How many chances do we need to tell Cody to stop sleeping with kids in the parking lot? That would be zero, like that's a one-strike rule, right? And so you don't always have to do a remediation plan. There is a teacher from Washington where the school found out that he'd slept with a kid. It was at a prior school. And so the teacher had gotten out of town ahead of the, the posse. And as soon as the school the new school found out about this old event, they fired him. And the teacher sued and said, hey, I never was given any improvement plan. I never had a chance to, get better. And the court said, no, you don't have to be told 5 out of 6 opportunities you're not going to sleep with the sophomores. The court said the teacher's conduct was patently unacceptable.
Just sophomore.
I'm short of sleep, so I'm hilarious. But do be aware that if you're going to say we don't have any chance to make it's so bad, we don't need to give the person a remediation plan. They're not going to get better no matter what. We have the burden to prove that. I think we can prove it in a lot of cases, but do know that we have to be able to back that up. The NSEA has latched onto this idea that a teacher has to be given a chance. They're going to sit in meetings and tell you, you are obligated to give this teacher a remediation plan. That's not true, but you are obligated to be able to go through the evaluation documents or some piece of paper and show that you've given the teacher concrete suggestions for improvement and a written list of deficiencies.
Another tactic they'll use in a hearing is, well, you could have done X, you could have done Y, you could have done Z. You didn't do any of those things, did you? Don't freak out when they did. You're right, I could have done those. I didn't do those. Here's educationally, professionally, why I chose not to do those. You get a chance to explain that away. You're the educational expert, you're the professional, so don't freak out when they try to say, well, you could have, I could have done a lot of things. It wasn't necessary, in my opinion. Here's why.
Yep, absolutely. And so that's exactly what Steve-O was saying there. Be prepared to answer why you used a formal plan in one case, but not in another case. You know, in Sally's case, she had issues with lesson planning. That was something that, you know, we needed to give her some additional instruction. In Cody's case, he knows to keep his mouth shut. He just chooses not to. So we didn't give him a remediation plan because we just told him to shut the heck up. But just the fact that they're asking those questions doesn't mean that you've done anything wrong. Just be prepared to answer them. I'm just going to swap screens. So I want to talk a little bit about deadlines. Every single time you give a teacher a directive, tell them when it has to be done by. And Trish Guinan, who's the director of advocacy now, has made this point really eloquently in closing arguments, and I've been kind of convinced by it, where she says, especially young teachers, they are used to a college system where the professor says, this is due by X date. So if you tell teachers, look, I want you to do a better job lesson planning, a millennial or a younger teacher might think they've got all semester to figure that out. And so telling them, I want you to use this lesson plan template and you need to have that in my office every Friday by 5 o'clock, that tells the teacher what you want, so it's better for the teacher. And it also is better for us because now we can prove that they didn't do what we told them to do. So every directive, even if you're making a suggestion, hey, have you thought about trying a behavior chart? Have you thought about trying this or that? I think you need to make a decision about implementing that by X date, so that we don't have this just open-ended so the teacher can float around and do things. And so here's a great example of being specific. Saying you must submit me lesson plans timely. What timely means to all of us is different. We all know that Karen time is a little bit different than Sherry time or Bobby time. And
anybody's time.
Maybe Mandy's. But saying, as opposed to saying, you have to have them in my office no later than 4 o'clock every Friday, that's a big difference. And saying you have to do weekly lesson plans, like this is a huge issue we come up against all the time. When you say weekly lesson plans, if you want them by Friday, you damn well better say Friday, because otherwise the teacher's gonna have them in Monday morning at 8:15. And again, I meet the deadline, I never beat the deadline. So articulating what the deadline is, I think is really important. But here's the flip side. If you're gonna give teachers deadlines and hold them accountable, if you give yourself any deadline, you better meet it. This is why when I write remediation plans, I never give my principal deadlines. I say things like, we will be in your room frequently and give you constant feedback. But if you've written a plan that says, I will be in your room at least once a week and I will meet with you weekly to talk about what you can do better, you have to meet that obligation. Otherwise, the NSEA is gonna have a field day that you're holding the teacher accountable and not holding yourself accountable. And then if it's March and you are done with this teacher, this is not the time to put an improvement plan in place. What you have to do at that point is go back and look through your evaluation documents, see if you have enough to meet those Rule 10 requirements. A hurry up remediation plan makes you look sloppy and unfair. I would rather not use a remediation plan if the deadlines are too short and just rely on the paper that you've got. But the NSEA will bully you and say you have to do one, and they know that if you do a fast one, it's going to make you look bad, so don't fall into that trap. So here is the pattern that we use for our plans. Each separate deficit is set out in a different performance goal. I don't like having more than probably 4 goals at a time. Personally, I prefer 3 because, you know, it feels holy. The heading is, you know, you will improve your lesson planning. And then the deficiency, when I've been in your room, your lessons often seem scattered and you're not prepared. Whatever it is that you've seen, tell them what they have to improve, give them a deadline, then list out the resources. So I've included a lesson planning template, or here's 3 articles from Education Week about the benefit of planning, or whatever it is you want to give them. Then tell them how you're going to assess their progress. I will review your lesson plans and make sure that they're meeting this template. And then the consequences for not meeting it.
Yeah. Want to add one thing real quick here, not about the substance, but Sherry will send out a link after this that has like cut-ups of the video, the updated slides. We've also included several examples. Yeah. They're very similar to the ones if you attended this last year when Karen and Steve did it. But basically, it's some straight up samples from real cases where we've obviously stripped out the names and some of the pertinent facts for our ethical purposes. But you can see a lot of this stuff borne out. So I just wanted to remind everybody, don't feel like you need to jot all this stuff down. If you're doing that, we'll send out some actual templates of both remediations and remediation plans, reprimands, improvement plans, all that.
I would add, I agree with Karen on the performance goal. I limit those to, sometimes I'll go up to 5 depending on the teacher, but what I'll also do, I agree, the fewer you have, the better. But at the very end, I'll add something like, I also had concerns about all these other areas. However, your performance in the first 3 are so glaring and so necessary to address immediately that we'll get to those later. So that way they can't say, well, gosh, you only had three complaints. No, actually I had about 20, but we're only going to focus on the top 3. So.
And the other, I love that you added that, because the other thing sometimes I hear is, Karen, I don't want to give her a plan because if she does all these things, we're going to have to keep her, and I don't want to keep her no matter what. So if you put those 3 things and then you add Steve's paragraph at the end that I actually have straight up stolen and put into some of the stuff I've written, it does make it so it doesn't look like no matter what the teacher did, you are always going to find something new. To own that at the very beginning, I think is really helpful. And then to hook onto what Bobby said, all the time here in the office, we say things like, I can't hear the music, or do you hear the music? It's so much easier to write these when you've read them. So looking at these examples, if you want to write them yourself, looking at these examples, I really think is invaluable. And that's why I don't judge you at all. I don't think it's a deficit as an administrator to call us and have us help you speak into them. In your career, you're going to write what? I don't know, maybe 1 improvement plan a year in your entire career. We write 50 a year. So it's just easier for us to hear the music. And so look at the examples, take a crack at it, but don't feel like we'll judge you if you need help, because we won't.
Some of this is the same stuff you can click through.
So yeah, no, I want to do this. So linking to educational practice and pedagogy, etc. I love to put in whatever your jam is educationally. I love to put some of that into the improvement plan, and here's why. If this thing does go to hearing, for example, I have some administrators that really dig Bloom's taxonomy. That's just something that they really believe in, and they think higher order thinking is the way to get students to achieve. I have other administrators that are very much into relational pedagogy, and they talk about student relationships and how that's just the most important foundational piece before a teacher can really be effective. You're not required to all think the same thing, but if I know what your jam is and we put that into the improvement plan, if this thing goes to hearing, I get to sit you down in front of the board and have you talk as an expert about stuff that you care about and you know. That just escalates your credibility in the hearing out the charts, but it also really makes you stronger with the board going forward on everything that you do. And so that's why I think it's worth taking the time to talk about, what is your educational philosophy? What is your building? Are you a building-wide best? Are you PBIS? Whatever it is, I want to know what your pedagogy is so that we can make you look good in front of your board. Then list the improvement required, the methods of assistance, and of course, always the deadline and the consequences. So let's go back to Cody. We got a couple of choices with Cody about what we're gonna do. I think you probably should issue a written reprimand. Tell Cody that his actions have been unprofessional. Tell him that that is impacting your trust in him and his effectiveness in the building. See that this is more than just your being an a-hole. It has actual practical impacts on our ability to be effective as an educational institution. So then Cody says, nothing. He's like, okay, fine. But Big Daddy shows up at the board meeting 2 weeks later and wants to intimidate the board. You're kind of concerned that the board's going to be biased because now father-in-law has shown his face and you think this thing might be headed to a hearing someday. And then after the board meeting, the UNICEF rep and Cody and probably father-in-law have gotten together and has written a scathing rebuttal to the reprimand that you get a week after the board meeting. Now what do you do? This is all still me, right?
This is still you.
Okay. So this is why I swapped the screens. I think that you need to look at the statute. This teacher is entitled to respond in writing, and you're required to attach it to the item that he disagrees with. Now,
the reason this is of course a different statute than the reprimand statute.
Yes.
Because he's missed the deadline, right? We're now 3 weeks after you met and done the reprimand, so he's missed the grievance deadline and the response deadline.
But you don't get to rip that up and put it in the trash can.
Exactly.
Yeah. So you have to attach it to the document with which he disagrees. And if anybody accesses the file, that has to be right there. And that's a game that the NSCA sometimes plays. They want to now look at the file, so they want to leaf through it, just make sure that it's paper clipped together. or if you have a digital file, make sure that you've made some kind of notation that there's a response.
Well, and this comes from Karen. We'll talk about the Bridgeport case later, but there was a teacher that went through on the eve of hearing and attached a response to every negative thing in his file going back 15, 16 months. And so the question is, and the board's question, well, why didn't you do this then? The short answer is this. You notice again, this is not the reprimand statute. This is not the evaluation statute where they have the ability to respond. This is separate and apart, and it says pretty much at any time they want to, they can go back into their file and attach a written response. So it doesn't matter if it's a year later, if it's 6 months later, if it's 3 weeks later. There's nothing you can do to stop that, but our opinion is you should always still have the last word if you can. So don't have them put things in the file that you're not also reviewing, and they can do that as part of their strategy preparing for hearing too.
Yeah, and one of the things that you do then, when they do this, you say, I directed you to respond within 7 days. You did not do so, so then I'm such a hag. You have been insubordinate because you did not file this scathing document timely. I will still include it in the file, but understand that I give it much less weight because you have chosen not to follow my directives, something like that.
Regardless of whether you agree or disagree that Karen's a hag for doing that, the union is absolutely having these types of conversations with their member.
Yes, they are.
You're not cheating. You're not playing gotcha by setting yourself up not to be caught in one of these and to prove to your board that, yes, I was on this from jump.
Yep. Okay, so let's talk for a second about the fact that we're worried that the father-in-law came to the board meeting. And we've had this happen too, where the teacher rallies the troops and comes to a board meeting, and then we're worried that the board is going to be biased, that the teacher is somehow going to be able to do something to make it so that the board can't give them an unbiased decision. So this is the statute that says the board is the one that has to actually decide whether or not we're going to cancel, non-renew, or terminate a teacher's contract. And then this is the wording from the Johansson case that talks about what does the board, how unbiased does the board have to be? And the Supreme Court said it has to be a tribunal that has an apparent impartiality, which makes me laugh because I don't know if that means they can know a bunch of stuff as long as they keep their mouth shut, or if it means that it's apparent to anybody that looks that they're impartial. But that's what the statute says in the Johansson case.
Not devoid of knowledge.
Right.
Although in fairness, we always err on the side of that because we certainly don't want anything from the administration or the school attorneys to the board to be the argument for bias. Much more preferable would be, you know, yeah, they heard it around town. That's why I think we have this word.
Right.
They're not devoid of knowledge, but we always put in all of our correspondence, we can't tell you anything right now, but the standard is not probably as high as we work on the assumption that it is when we work with you.
And quite honestly, we've had, I don't know how many cases in a row where the NSCA attorney or representative has made a bias challenge of a board member.
Yeah.
And in several of those instances, we agreed. You're right, they are biased, and we made them one of the best witnesses we had in the case. And so it's not always a bad thing as long as we have enough board members left for a quorum and to get a necessary vote. It's fine. They turned out to be some of the best witnesses because they have great information.
The other thing, and we have the Bridgeport case later, but this exact argument happened in that Bridgeport case. The teacher, and I can use his name because he appealed and put it into the public record, Patrick Robinson was complaining that the administration was treating him badly, and so he showed up in front of the board and complained about it. And then his lawyer argued that the board was biased because Robinson had come in front of the board and told them a bunch of stuff. And the Nebraska Supreme Court was just not buying it. They said a teacher cannot finagle the facts themselves to make it so that the board is biased and cannot take employment action. So I'm not worried about Cody's father-in-law in this case. Now, I would tell you that I probably would have, if you called me before this, you don't have to have public comment at every one of your meetings. And so you certainly could have gotten it so that father-in-law couldn't say anything, at least for a couple of months. But if you feel like you have to let father-in-law have his say, I don't want you thinking that they can now bias the board so that there's nothing we can do. So moving forward, I think, so this is like when you do a classroom observation, you're supposed to talk about what you see in the classroom, but that doesn't mean you can't include other stuff. So every time you do Cody's evaluations moving forward, in personal and professional, wherever that is on your rubric, but you have to have it, I would say, I continue to be concerned about the damage that you've done to your relationships within the building by constantly itching and stirring the pot. And I would just hammer that over and over in the evaluations. That is in addition to the reprimand that you've already given him, right? So this reprimand can do multiple duties. It can be a reprimand. It can also be the basis for you talking about it moving forward in Cody's evaluations. It shows that it's a really big deal. Sometimes if you reprimand and never refer to it again, the teacher assumes that everything's fine and hunky-dory, and then it feels like cheating when you bring it up later. And it also fights the NSCA hearing tactic. Now, see, I don't care about this. The NSCA will say, did your lawyer prepare this document? First of all, we never do the first draft of the classroom observation. I want you to do that first draft because you saw it. But us doing a first draft of a reprimand, that doesn't give me any heartburn at all. So did your lawyers prepare this document? I conferred with legal counsel. They prepared a draft, but the thoughts in here and the ultimate conclusions are mine. And in the meantime, we're losing our minds objecting because of attorney-client privilege. But I don't want you, so sometimes it's a gotcha move to make you look scared and uncertain. Yeah, of course I conferred with my lawyer. What do you think this is, my first rodeo? Screw you, of course we call. Did the teacher call you, Miss Union Rep? Yeah, she did, so there you go.
This is part of Karen's thinking throughout this, we'd be talking about it. This is a tactic that they use.
Yeah.
Just to try to get you flustered on the stand.
Exactly.
And I find it amusing just because their representatives write their responses to reprimands. Their representatives write responses to evaluations. Their representatives write requests for hearings. Teachers don't do those things.
Right.
And so both sides are doing the same exact thing, and there's nothing inappropriate about it.
So yeah, just don't freak out. And then with Cody, I'd start building the case for non-renewal because I don't think Cody's not going to get better, and it's going to be harder when he's tenured than now when he's a probie. So I would start now obtaining statements from staff members. Here's why. If you wait until he's made a hearing request and you're like on the eve of hearing, they're super freaked out. Getting them to put stuff in writing now, at least you've dropped anchor and you have, what Mrs. Johnson said that Cody said in the teacher's lounge.
When you're preparing for a hearing and those teachers that were really strong when they came in 6 months ago talking about how Cody's damaging our culture, suddenly they get this, scaredness that kind of comes over them. They don't want to testify. They don't want to talk to you. Having something in writing from the time when it actually happened is the easiest way to tell them, we're going to introduce this because I think what you said here is true. Is any reason that it's not true? Well, no, I just don't want to testify.
Yeah. And if you really have somebody that just truly just doesn't have the gumption to actually testify, we at least have a document that we can now fight about whether it gets in at the personnel hearing. So getting it in writing, even an email, that would be fantastic, but 100% get it written down. Any parent or student that complains, get that documented. Again, typically people don't want to sign anything. They feel like that's, Cody's going to target them or go after their kid. But saying, hey, could you jot that down in an email so I know I've got it? I'm going to make some notes, make sure that they're correct, but somehow try to document parent and student complaints. You can, so the idea of progressive discipline is one that I don't really care that much about, but if you want to have progressive discipline, it's pretty easy to put that together here, right? One, Cody, knock it off, and then put an email together. There's your oral reprimand. Two, you issue Cody a written reprimand. Don't ever do this again. And if it continues, Cody, I'm reprimanding you, and I'm sending you home for 3 days for you to consider your misconduct and come back with a renewed sense of purpose. That shows that you're, making it get progressively harsher. And then you might consider an improvement plan. I love making teachers read books to change their hearts. I don't know if it ever works for them, but it makes me feel better. So, read a bunch of John Garden, read a bunch of, like John Maxwell, stuff like that. I like doing that. And then I make them write reflections. And so here's the thing. If Cody's writing these reflections and it's stupid, he shows that he thinks it's stupid, and his disdain for the district comes through loud and clear. Those are fantastic exhibits in a personnel hearing. If Cody really is, struggling, I just was reading a teacher had been made to write reflections, and the teacher wrote, I think maybe I should make some friends. Like literally, she wrote that in her plan. It's like, holy crap, yeah, you might, maybe some therapy. Making the teacher read this stuff, even if it doesn't change their heart, it's still an extraordinarily useful exercise for us as the attorneys. And if it really helps somebody get better, so much the better. So that's what I would do with Cody moving forward. This is a problem we're going to have to manage. We're not going to solve it immediately, but long term, I think Cody's going bye-bye because I don't think he's ever going to improve his attitude.
So that's it. We're at about the halfway point here in the slides and what we're planning to cover. It's 10:21 on our end, so we'll probably, what do you think? 10-minute break?
Yeah, let's take a-
Download coffee, and then our hope is we've got 3 more hypos, but those will go quicker. We did a lot of the heavy lifting here, and so our hope is that then we'll come back, probably see if anybody has any questions.
Yep.
Then we'll jump into our last few hypos and finish up with some of the cases about what the courts have actually said about some of these issues.
So 10-minute break to be back here at 10:30.